Welcome to the official Lawyer Minds podcast. Lawyer Minds is an ever-growing ecosystem for all the resources modern lawyers need. As the official Lawyer Minds podcast, we'll discuss everything from the latest happenings on the website to industry news. Get ready. Here we go. It's time to dive into the minds of successful lawyers. Here are your hosts, Tad Thomas and Mike Campbell.
Mike, good to see you again.
Hey, how are you, buddy?
It's been a little while since we did this.
It has been a while. Hopefully people are still tuning in. We'll find out, I guess.
Yeah, I guess they're going to have to maybe resubscribe. I know if I don't listen to something in a while, then it pops up and tells me I got to resubscribe to download it.
Well, hopefully our audience has a little bit more grace than others, given, people who are listening to this probably pretty busy too.
Yeah, I would think so. Well, it's good. We got a couple good interviews coming up in the next couple weeks.
Very excited. We're, I don't have a break, or you don't have a break in trials. I do. And so, but you've got 3 coming up, and we're going to try to knock out a couple episodes here and then maybe come back middle of summer and do some more.
Yeah, I've got some ideas. So we've got Josh Koskoff for an interview. We've got an upcoming interview with Linda Libson, who is the CEO of AAJ. And then we just set another one with Jamal Alsifer to talk about the damages phase, a follow-up to his first interview with the Silver Spring shootings.
All very interesting. Sometimes I just like being a passenger on these and just listening. So, these are all very interesting topics and guests to talk with.
Yeah, we've been pretty privileged to have some pretty high quality interviews.
We have.
And this one with Josh, I'm really excited. They have taken, what I thought was an impossible fight and took it straight to Remington and won. And, what by all accounts was an impossible victory. So I can't wait to hear how they did it. Yeah,
absolutely. I'm definitely looking forward to it.
Yeah. Without further ado, all right. Our Josh Koskoff interview. The Lawyer Minds podcast are brought to you by Gavel Video. Some companies do videography, but Gavel Video does high-quality cinematography to highlight your firm's successes. Also brought to you by Legal Insights, providing expert digital marketing for law firms. And finally brought to you by iLitigate, trial presentation software for trial lawyers by trial lawyers. And now to our program. And we're on today with Josh Koskoff. Josh, thanks for being on with us.
Thank you. Really appreciate it.
Josh, let's start. Tell us a little bit about your firm. You obviously are from a storied firm. Tell us about where you practice and your practice.
The firm is a Connecticut law firm. It was started by my grandfather. His name was Ted. I called him Papa, but he was a legend in his own day, I guess. And then my dad, worked with my grandfather. And they worked for about 20 years together until my grandfather died. And then I decided that to try law school. My dad said, I said, I don't know if I'm cut out for it. My dad said, well, give it a shot. You can always drop out. And I thought either that was great advice or terrible advice. But I went to law school and then got the pleasure of working with my dad for about 20 years until he died a few years ago. It's a family firm, but we do. Now once upon a time, we were literally family. Now we're figuratively family.
Right. So I want to go to the Remington case. So 2012, I guess, some nut job murders 20 first graders and some teachers. And I guess, let's go back even before the case. Where were you when you first heard about the case or the shooting? And, tell me your reaction.
Yeah, I remember exactly where I was. I was in my office. I was actually around the corner from my office in Bridgeport. Bridgeport's about 20 miles from Newtown. So it was really, I heard about this shooting at a school. And then actually the first time I saw it on kind of scrolling on the TV at this cafe around the corner from my office. And I thought, wow, I started filling blanks. First of all, I didn't know it was in Connecticut until a few hours later. Then I just imagined that, that was terrible. And I thought it must be like a estranged husband who shot his, I imagined a substitute teacher wife or something like that. It never dawned on me that it could have been somebody who would have gone on this kind of an ambush and a rampage.
And then
slowly, just to be in Connecticut on that day, anywhere, I'm sure most of your listeners recall where they were. It's one of those events like 9/11. But I think if your experience was like mine, there was this rollout of information. And of course, we were all following it online at some point. And there were these things that turned out to be wrong, things that turned out to be right. And it was just a long, painful day for everybody.
Right. And then, so when were you all approached by the family about pursuing a case?
Yeah, well, actually, from me personally, it happened incidentally, actually. I was getting a ride to the airport to go fly somewhere for a deposition. And the driver, we got into a conversation with the driver, and he said he worked with somebody whose daughter was killed in the shooting. And it turned out that person was one of the adult teachers who was Victoria Soto. And the father, Carlos, was the friend of the driver. And so I said, look, I'll help out any way I can. I wasn't thinking of a lawsuit, Tad, at that time. I was just thinking of helping, probate, whatever we could do. They were thrown into this shattering situation. And I just wanted to help like any other lawyer would who had the opportunity.
Right. So, for most of us in our world, we know about PLCAA and the federal statute that essentially makes gun makers immune from suit. So it kind of talked to us about how you went from, hey, anything I can do to help, to maybe there's a lawsuit here, to, hey, let's go right after the thing that's, in my mind, causing a lot of these shootings, and that's the immunity of gun makers.
Yeah. Well, I guess I'm not sure this is a shameful admission here, but I didn't know anything about PLCAA. I think most lawyers, I would have guessed, didn't, because if you've been an attorney for any length of time, there was never a vibrant, there weren't a lot of gun cases to begin with. There are natural barriers to bringing a case against a gun company that exist at tort law. So I was sort of blissfully, I guess, ignorant about PLCAA when we first started looking into potential cases. And we didn't just look into the gun case. I considered a case against, Activision for their Call of Duty. I considered a case against the school. We did sue the estate of Nancy Lanza. We thought that was appropriate, failure to secure the firearm. But at the end of the day, I kept coming back to the gun. And I also, being from Connecticut, it's a different part of the country that you are from. I didn't grow up in a culture of guns. So I also, not only did I not know anything about gun litigation, but I also didn't know anything about guns themselves. So I had to do my homework to advise these families. Initially, I worked with my dad a bit, and he was very optimistic. And we were working on a theory of like products liability. Why doesn't this gun have palm print technology or biometric technology to prevent a third party from using it? I still have that issue. Like, I'm talking to you on an iPhone. You can't use my iPhone and I can't use yours. Why can't that be implemented with a firearm? But in any case, that's about that time is when I stumbled on PLCAA. And I said, whoa, what is this? PLCAA, for those who don't know, is short for Protection of Lawful Commerce and Arms Act. And that is the so-called federal immunity that was passed in 2005, which was really a present to the NRA. It asked Congress to give the gun industry a leg up in what is otherwise a balanced legal system, right? So that's exactly what they did. But it turns out PLCAA is not absolute. PLCAA has exceptions in it. And so we started looking at the exceptions, and I started working with two of the exceptions. One of them was called negligent entrustment, and the other is called, commonly known, the predicate statute. So basically what Congress did was they said, we'll prevent certain lawsuits against the gun industry, but we're not going to protect the gun industry if they break state law in the sale or marketing of firearms. And we're not going to protect the gun industry for negligent entrustments of firearms. And I thought, when I learned about the AR-15 and where it actually came from and what its actual DNA was, my real thrust of my legal strategy for a while was negligent entrustment. How can you take this combat weapon designed for our brave soldiers and military to use to kill the enemy in battle, in battlefields, and in, now in urban settings and all sorts of different combat scenarios, and to a trained military, and just sell them to anybody who wants one if they turn usually 21 in the commercial market. That didn't seem reasonable to me. That theory didn't work. It was too broad. I think I cut too broad with the court. The other theory was based on a violation of a state statute. And that's again, one of the exceptions. And the state statute I'm talking about in Connecticut is the statute that governs the marketing and business conduct of businesses that want to do business in Connecticut, called Connecticut Unfair Trade Practices Act. And every state has one of these.
Right.
So that was where we were headed. And that had to do with the marketing aspect of this AR-15, in particular the AR-15, by this gun conglomerate. And I learned quite a bit about the business of the gun industry. And what I always knew that this was it had to do with a gun, a particularly infamous weapon that is still being used in combat by our soldiers. But what I didn't realize is that at the heart of this case was really just old-fashioned greed. And that's really what caused all these problems in my mind.
So when you started digging into the marketing that Remington did of the AR-15, what were you finding that caused you to say, hey, this is a violation of the Connecticut statute?
Well, I didn't know about the weapon. I certainly didn't know about the marketing either. And when I saw the marketing, one of my families who lost one of their children in the shooting, the mother of one of the kids was online the week after the shooting and started and found some of the marketing that was done by this gun conglomerate of their Bushmaster brand. And it horrified her. The marketing once upon a time was very dry, very responsible marketing of AR-15s, which were always available in this country commercially. But you didn't have mass shootings like we have now. When we were growing up, I mean, can you remember a single mass shooting with an AR-15? Right. They didn't, because they actually did not, there weren't any, even though AR-15s were readily available to anybody who wanted one. The thing is that what I learned was that the natural, or they call it an endemic market for the AR-15 would be just, anybody who had an interest in an AR-15 would have to pursue purchasing one, right? But they could do it easily. But there was a small market for 40 years. They averaged about 100,000 units. And it only was about 5 small shops that actually, niche shops, firearm shops that actually made them. Remington was in business for 200 years, never made an AR-15 until after its acquisition by this private equity firm. So that surprised me because remember, I was thinking that this was all about the gun, but the gun was always on the market. So what was the delta? As of 2005, they were doing about 100,000 a year. By 2012, the year of the shooting, they sold 2.1 million in a product that was on the market for 40 years. I mean, it's almost unheard of. And the product itself didn't change at all. The only thing that changed was the marketing. And so the marketing was much more aggressive. Instead of waiting for people's natural interest in the weapon to lead to a sale, it became much more aggressive. They tried to convince existing firearms owners why they needed to add a combat weapon to their hunting rifle, their shotgun, whatever, natural, things that were designed for particular purposes other than killing. And they were successful at that. And they tried to expand the market to a younger market, to people who had never owned a firearm. And so that's where they really crossed the line, especially with the Bushmaster brand, which really promoted criminal and assaultive use with the weapon. And if you just take a look at it, when I first saw it, the marketing that was publicly available, I said, well, that ends the liability case. Like,
Right.
you just, if you held it up to anybody, and I think gun owners also would just say, this is just wildly irresponsible. So I really wasn't worried about proving the immorality or amorality or lack of responsibility in the marketing. The more difficult hurdle was the connection with the shooting, which I also had an inside track on, just based on my own personal experience, as it turns out, playing Call of Duty.
Josh, it's interesting. You were talking about the digging into the marketing and how a gun owner would be offended by it. Confession I have to make is up until Sandy Hook, I was raised in a gun culture. I was around guns growing up, owned guns, had a very sort of, I guess if you want to call it, liberal view of the Second Amendment. Mm-hmm. And then Sandy Hook happened. President Obama comes on TV, and it's abundantly clear that something has shifted within me, and I think within a lot of other people, about what's going on here. But if we were to talk to pre-Sandy Hook Mike and a lot of the people I still know about what is wrong with the marketing, because that's the point that they make regularly, which is AR-15 doesn't stand for assault rifle. It has to do with the make. It has to do with but if you're talking about the marketing, how do you appeal to someone like me if you're trying this case to a jury and explaining to them that this is just out of bounds?
Right. Well, the first thing I would probably do, and I don't want to I'm not interviewing you, but is,
go ahead.
This idea that, I don't know if you naturally, and growing up in your family, did anybody seek or desire an AR-15?
Yeah. I remember shooting an AR-15 growing up. My stepfather had one. I knew plenty of people who had them as well. Yeah.
So you probably, that means that there were people in your family who were naturally interested in the AR-15 and were likely very responsible people, because they weren't being targeted by what in the back of the deal was in this case was a private equity firm just trying to sell as many of these weapons as they could to as many people. But but your family must have had a natural interest in owning different types of firearms. So they would be considered like responsible users. And, there is some truth to the fact that people kill people, or at least they have from time to time, certain people have the impulse to kill people, right? So the problem with the marketing here was that they promoted the lone gunman on a battlefield. They appealed to kids and teenagers, quite literally, through game product placement. They put they taunted risky potential users with slogans like get your man card, or your man card has been reissued, with the AR-15. So it was no longer just a firearm that was available to responsible people who had a natural interest in it. It was saying, you need this firearm, you troubled young man, because this firearm is going to confer masculinity. And understand that this is occurring at the same time that the internet is sort of expanding. So we're in the mid-2000s here. And this is when the market exploded for these firearms. And it does pivot around this marketing strategy. And so it wasn't the parents that were being targeted. It was the young adults, or in many cases, the kids and the teenagers. I think that most responsible firearms owners would say, you shouldn't target children and teenagers and troubled people with combat weapons with the message to kill and commit lone gunman assaults. Like, that's irresponsible. Just like you wouldn't stand for Ford Motor Company promoting one of their cars to run over people. I think that there's, so what I would say to people who are firearms owners is, Remington is a great example of a company that proved that you can sell firearms like any other business and do so responsibly. For 200 years, that's what they did, until they were taken over by this private equity firm. And then in about 10 years, they bankrupted this 200-year-old company, not once, but twice. And they did so simply because they lost their way. And Remington, again, never sold an AR-15. Didn't feel the need to. They had their hunting rifles. They were very, again, very responsible. They knew they were good to their employees. Income's this private equity firm, and they start firing people. The product goes south in terms of quality. The culture is gone. It's all about money. So I would say to them, look, it's like any other business. Just act. They should act responsibly. And this isn't about taking anybody's weapon or gun away from them.
It's really interesting how it does tie into it's about the money. I didn't know the part about venture capital or private equity coming in and doing what they did with the company. That's interesting. So you come up with the legal theory and you file suit. Kind of walk us through what happens next.
Well, we had two legal theories, and my negligent entrustment theory. The way I like it is like I'm looking at this mountain ahead of me. I didn't even know it existed, this placa, this immunity. And we just tried to find paths up the mountain. We found what we thought were two. We filed the case. We got into a little bit of discovery, and then the judge dismissed the case, the trial judge. And we felt that we must have not made I don't know, you've probably had the situation maybe where you file a case and something doesn't go right and you think, is there a way I'm framing this case or the way I'm telling this story that maybe isn't effective? And what is it that the judge missed? Because the judge is a smart judge. And we started to think about it, and we realized that we weren't really explaining how the narrowness of our case. We're not saying that anytime you sell this firearm, it's automatically irresponsible, because again, they were selling this firearm for 40 years responsibly. So we really pivoted towards the way they targeted young users with this marketing, and that went up to the Connecticut Supreme Court. And the Connecticut Supreme Court, we had an oral argument, and we waited for 15 months for the decision. Oh. And my life went on, the families remained implacable, steadfast, but I had run out of excuses for how long it was taking. And then one night, we got word that the decision was coming out the next day. I don't know, usually you get more time than that, but I was visiting my dad in New York, who was very sick at the time. And I left the next morning. We were all huddled around, and we started reading. The decision came out. We started reading it, and it was one of those decisions where you really can't know whether you won or lost. I thought we won, and then I thought we lost, and I thought I think we won, and then it turned out we all agreed we won, and then it was like a complete all of that anxiety that had built up over 15 months, like you're waiting for a verdict. I realized, but it took 15 months, and the verdict was a great verdict. It just came out of us. And I remember what came out of me was something like prehistoric. I mean, I never remember, but it was just pure, unadulterated, like euphoria and reliefs of all this anxiety. And then we had no sooner were we coming down off that experience, then we realized that we were met with this petition for the U.S. Supreme Court. And I thought, man, in this case, it just never ends, the hurdles in this case. And that created its own second round of anxiety, because we knew if the Supreme Court took cert on the case, it was likely not a good sign. And there we got, we had one of our strategies that we decided, and I was really vigilant about this, was I thought we had to maintain control of the case at all times. We didn't want to affiliate with one of these gun groups. No offense to the groups that work in this area, but we just didn't want this to be a political case at all, because it isn't a political case. It's a business case in essence. And also, it may be apparent, but when the shooting occurred, the shooter didn't line up Democrats on one side of the room and Republicans on the other side, or kids of Democrats and Republicans. The shooting was indiscriminate. So this affected children, no matter what their politics were or their family's politics. I certainly didn't want to get into a political issue, but I'd never had a case potentially go to the Supreme Court before, and I knew there was an art form in the way petitions were handled and the way to not call it essentially to your case. And so we had a lot of, you may have had these experiences, you get a lot of solicitations by different appellate firms because if there are very few cases that actually go to the Supreme Court and they want the opportunity to argue if they do go to the Supreme Court. And we ended up accepting the help of Don Verrilli and his terrific team out of Munger Tolles. Don was the Solicitor General under Obama, a very well-known appellate lawyer, and worked with him on, or I should say, he did the heavy lifting on the brief. We just provided our own, edits to it, but it was magnificent. And if it was a straight up legal analysis, there's no way at all they should have taken the case because there was no traditional rationale. There wasn't a split of authority. It was not a final judgment because we were going back to trial. So you had this interlocutory nature of the appeal. But on the other hand, it involved guns. And anything that involves guns has this special aura about it, even if the case itself is really mostly more about the business of guns than it is guns themselves. So we got a denial of that. And that was, and then at that point, we were wide open for discovery.
And you had to be excited. Now you really get to do your real work, right?
Yeah, it only took about 6 years. But I have to just take a moment to say that one of the things that I was always motivated by, and our entire team was just the sheer patience and determination of the families. And in fact, this was not an easy case to actually bring, even though we believed in it. And I drew so much motivation from them. And I kept thinking, if these families who had other kids to raise, had their jobs to go to, if they can get out of bed in the morning and put one foot in front of another, we can try this. I mean, we can tackle this case. And these families have lost everything. They have nothing to lose, and they want to make a difference. And so that remained really motivational force that allowed us, I think, to keep our heads down for that long. But we also wanted to drive a truck through the discovery opportunity. Mm-hmm. Frankly, I think I could have put the case together without any single document from the other side. Again, everything in the gun industry was so in your face and publicly available. Even before the suit, I had a case kind of lined up. But I also understood that there was expectations that we would get into the boardrooms of this company and turn it upside down, basically. And that's what we did, I think. The other thing that happened was there were a couple of bankruptcies that were unexpected.
I was going to ask. Yeah. So not only, so you go through all these appeals, you come up with this novel legal theory that has not been adopted in any, by any other court till now. And then after you finally get the chance to engage in discovery, then they go out and they file bankruptcy.
Yeah.
I mean, did you just have to bang your head against the wall at that point?
I did. I remember thinking, of course we're going to bankruptcy court. I mean, that had to happen. And actually there were two bankruptcies. One bankruptcy was a reorganization. I talk about a crash course in bankruptcy. I mean, I don't know about you. I knew nothing about bankruptcy, and we got some help again in that department from some bankruptcy lawyers who did a great job. But the first was a reorganization that occurred during the time the appeal was sort of pending anyway. So it was sort of what do they call it? Concurrent term, basically. Mm-hmm. We were serving a sentence that was both the time period of the appeal pending and the bankruptcy. So I got a little bit of an experience then, but then I think I did 5 or 6 maybe depositions. We'd gotten a bunch of discovery, and then all of a sudden bankruptcy number 2. And bankruptcy number 2 was a whole different ballgame because now Remington was going to be put up for sale. And of course, I was as paranoid, I guess, or suspicious as any trial lawyer would be. I'm like, they're doing this to get out of the case. And actually, I'm sure the case didn't help, but I don't think it was just a matter of it being run so poorly. And they actually did basically drive this 200-year-old brand and several others that have been well run, basically brands, into the ground in pretty short order. And that's sort of what happens when ironically, I think when money is the only objective, and that was the only objective of this firm, this private equity firm, to make $1 billion gun conglomerate. It takes more than money to have a successful business. It takes a culture, it takes personal investment, it takes guiding principles, and they were all stripped from these brands. So, but I'd be lying if I said we didn't feel this was a potentially existential threat to our case. And as it turns out, we were able to get out of the bankruptcy court after a long and arduous process. And we were sent back to Connecticut, and then was able to get some more discovery under our belt. And then things fell into place in terms of the settlement. I think what we had proven along the way through our discovery, our depositions, was that we had a very solid case. And I think there was never a question about the damages either. So we were able to put together a really, I don't think we could have done any better from a legal result given the situation. We were able to get every dollar that was available from the insurance tower. And that was important, not really so much for the compensation of the families, but for the impact they wanted to have to this industry, because their goal was never money. It was to make a difference in this industry so that other families really didn't have to go through what they did, or lower the risk of that. And this was an industry that really courted risk. They didn't try to, it wasn't like the automobile industry trying to sell you the safest car, right? This was an industry just courted risk and felt they had no responsibility or skin in the game. We all know there are many factors that go into this problem, but certainly one of them is the conduct of an industry that doesn't seem to look out for issues of public safety. And so that was important because the payment also, I think, shattered the myth that this industry was above the law, immune. And that's really important, not just for the industry to start acting responsibly, but also for the insurance industry that underwrites the gun industry to understand this is not like easy money, that there is risk out there. And that, it taught me a lot about what we all believe are the best aspects of the law, that our system is really important to keep this balance between just sheer profit-driven pursuits and looking out for the community, acting responsibly. And lawsuits have that, we forget about the prophylactic part of lawsuits, the part where it forces industries to act reasonably just simply because of their exposure. And I think that, and the hope here is that perception of immunity being shattered now will result in some things that actually some steps that actually save lives. Otherwise, really, what's the point? And so that was a big part of it. And then the other part was there was never going to be a deal ever that didn't allow for the public disclosure of the documents and the discovery. And that's sort of phase two. And why did the families want that? Well, they wanted that, again, because they felt that a lot of times people need to see things themselves, the evidence themselves, to be so that they can make up their own minds. And so, again, to educate the public, to educate anybody who's interested in this issue, so let everybody know that what went on behind closed doors was not acceptable, and that nobody really, in Mike's family or whoever's, would condone this conduct. If your local ice cream shop engaged in the type of conduct that this company did, you wouldn't eat ice cream there anymore. So that's sort of the whole gestalt there.
Well, we had a lawyer from New Orleans on our podcast not too long ago, and he talked about you take the cases that need to be taken. And this was clearly one of those cases that needed to be taken. And fortunately, the families found themselves in the hands of a good firm that was willing to take the risk and spend the time. So congratulations on such an incredible result, Josh.
Well, thank you. Thank you very much. Really appreciate this opportunity to speak with you guys.
No, thanks. And we're going to upload, some links to the opinions and things like that when we upload our podcast too, so people can be sure to check it out and look at the ruling and see that there's finally an avenue to hold, these gun makers accountable for their conduct.
Great. I'll send you guys the complaint too, which sort of lays out the general facts. It's more of a story than it is a legal document. So you might be interested in that. Your listeners might want to take a look at that if they're interested in the case.
For sure. No, that'd be great. Josh, thanks so much.
Thank you. Really appreciate it.
So, Mike, Josh is kind of like you. He's actually a smart lawyer and can come up with these amazing legal theories. For those of you who don't know, my partner, Mike Campbell, he sends me texts at all hours of the night talking about all of these crazy legal theories. And so, one of these days you're going to come up with one just like what Josh did.
I don't know. I mean, he's a pretty sharp guy. He comes from a pretty, well-known lineage of good lawyers. And I appreciate that compliment, but it sounded like Josh was in the right place, the right time to apply those skills that we all learn and find some justice for these folks and send a message to the gun manufacturers.
Yeah, without accountability, why does anyone have any incentive to change their conduct? And the fact that now in the civil justice system, which has been providing accountability to all sorts of other companies and industries, now finally we can provide accountability to the gun manufacturers as well.
Yeah, I mean, when you talk about constitutional conservative values, Second Amendment, there are several other amendments too that are worth discussing, notably the Seventh Amendment, right? And the importance of the Seventh Amendment. And so the fact that they have been able to escape the courtroom is pretty profound, but also the things that they're doing behind the scenes, limiting the amount of research that goes into whether or not this is a health issue for the country as a whole. It kind of maybe speaks to they don't want anyone to find out what kind of marketing they're engaging in, like Josh discovered.
Yeah, that was really interesting. I know when we talk about the Juul cases, and we need to get somebody involved in that litigation, how Juul essentially took all of the cigarette marketing that went to teens and duplicated it and made it applicable in the 2000 teens. And now you've got, gun manufacturers essentially doing the same thing. And I remember, I mean, it was not as pervasive, the AR-15 and the talk around the AR-15 until, right around the early 2000s and 2005, 6, 7. So it is interesting that goes directly to the marketing.
Yeah, I mean, I grew up, and I mentioned this in the podcast, and I know you grew up in cultures where guns are very important for a number of reasons, hunting, protection. So, one of the things that I always heard was, well, when I grew up, and this is for me and for people in the generation before me, we would go to school and see gun racks in the back of trucks. Mm-hmm. And how, it has to be something with, video games or something wrong with the kids or something or other. And it's like, Josh stumbled onto something here that makes a whole lot of sense.
Mm-hmm. I mean, why would it be any different in the gun industry than pharmaceutical industry, tobacco industry, alcohol? I mean, in all of them, it's the marketing that made these things cool and created a problem that wasn't there prior to the marketing. Yeah.
And outside, when we were done with the interview, I think I mentioned Joe Cool with a machine gun.
Yeah. Mm-hmm.
This is Joe Cool with a machine gun. It is specific marketing to an age group, and the intent is to sell weapons at any cost. Mm-hmm. And that was the same thing with, like you said, with the opioids and then also with tobacco. I wonder if the genie is too far out of the bottle. You know, the marketing has already been put out there. The damage has already been done. What can we do to, you know, reel this back in? I don't know, but someone has to be held to account. I'm sure glad that Josh did that in this case.
Yeah, it's certainly a chink in the gun industry's armor. So, you know,
it is. The biggest thing is, you know, he pointed out, and if you're listening to this and you're not sure, some people will always, most of my clients, I think most of all of our clients, Tad, will say, look, we just want something to change, right? You know, we're not in it for the money. We want something on the conduct of these folks to change. And sometimes what I'll tell them is when we get down to the nuts and bolts of it, the insurance company that provides the coverage for this company will make sure they change, because they're not going to pay out. They're not going to continue to cover if this person continues with this type of conduct, or this company continues with this type of conduct. And Josh's point on, hey, we want the insurers to know that this is an issue, it speaks a lot to maybe how we can affect that change. Like the moment the insurance companies say, we got to have, this has got to be tighter, we've got to have more restrictions on what you're doing marketing wise, things could be affected by that.
Good podcast, Mike. All right.
I think so. Yeah. Yep.
All right. See you.
That wraps another episode of the official Lawyer Minds podcast. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content Lawyer Minds has to offer, and engage with us on social media. Your feedback on the show and ideas for future shows is always welcomed. See you next time.